Hello. So in this video, we're going to talk about fair use. In the UK, I think it's called fair dealing. I think that might also be the term in Australia and New Zealand and some other Commonwealth countries. But in the US, it's called fair use. This is an exception to copyright protections. I want to give the same caveat I gave in my video about copyright itself, which is that I am not a copyright lawyer. Don't take the stuff that I'm saying to be the best representation of copyright or fair use law. But fair use is a purposeful exception to copyright protections. Because again, copyright protections basically prohibit the reproduction and distribution of people's intellectual property without their permission or without paying them for it. Now, there are a lot of things that do not count as fair use. And actually, fair use is a somewhat contentious idea. Basically, fair use, the principle of fair use is that there are certain conditions under which it is justified to use someone else's intellectual property when that use does not compromise their intellectual property rights. So, what does that mean? Well, basically that means there are particular situations in which you can use copyrighted material for educational purposes, for the purposes of criticism, for the purposes of parody, etc., often, but not exclusively, in non-commercial contexts. One thing with fair use is that this does sometimes still require citation, depending on the particular context in which you are using that material. So, for example, if I'm writing a scholarly essay about a particular play or novel or poem or whatever it is, and I want to quote material from that, that falls under fair use because I am criticizing, because I am making a critical argument or interpretation of that material. So that generally is covered by fair use. I can use I can incorporate into my essay someone else's intellectual property, provided, in this case, that I identify it as someone else's intellectual property. And usually that is done with a proper citation for whatever journal or book publisher or whatever it is that I'm publishing with, quotation marks if it's direct quotation, all that stuff. So that's one very common fair use exemption, is critical use of material, analysis, argumentation about someone else's intellectual property. Another very common use is for nonprofit educational purposes. And this is an important distinction because, so my one office mate, for instance, who sits at that desk behind me, in addition to teaching here at Penn State, she does a business that basically plans curriculum, sort of. That's a basic gloss of what it is. It's a sort of knowledge system that schools can purchase access to this system. And so when they use copyrighted material in that package, because they are going to sell it to clients, fair use does not apply. However, when, for instance, she's teaching for Penn State, if she wants to create a slideshow that uses copyrighted images that will be shown to her students, or if she wants to put up on Canvas, our electronic course management system, a portion of someone's book though normally you wouldn't legally be able to reproduce and distribute that necessarily. But when it's for nonprofit educational purposes, that is for the purpose of directly teaching your own students, fair use applies here as well. There are some caveats to that. And actually, to an extent, there's caveats to the criticism one as well. There are, particularly with longer works, there are limits to how much you can reproduce from those works. Different states have different guidelines, different countries have different guidelines. Usually, I think it caps out at like 10 or 20% of the total, but those guidelines are often, again, not necessarily enforced in a classroom setting. If I'm teaching a particular textbook and I put 25% of the material up on my Canvas page, it's unlikely that the author of that textbook is A, ever going to know that I've done that, or B, pursue me for copyright infringement. And even if that were the case, it's still possible that in an actual copyright lawsuit, I could make the argument that this should still fall under fair use. That's actually a really important caveat with all of this fair use stuff. This is one of the big problems with fair use, is that while there are vague guidelines, this is at least in the US, and I think this is sort of true in other, at least English-speaking countries as well. In other countries, I have no idea what their copyright laws are necessarily and what, if any, sort of fair use exemptions there are. I know the US system and a little bit about the British and Australian and New Zealand systems. One of the big problems with fair use is the guidelines just aren't that clear and specific. And so if you ever find yourself in a lawsuit where someone is saying you have violated my copyright and you're saying this falls under fair use, or if you are attempting to sue someone for violating your copyright and they're claiming that it's fair use, it kind of depends on the judge who decides the case. And that's a big problem, legally speaking, because it makes it hard in some cases to determine whether or not something you're doing technically falls under fair use. Now, for the purposes of criticism and nonprofit educational materials, that's generally not that much of a problem, in part because people rarely go after criticism or nonprofit educational use of intellectual property. It does not tend, basically the idea is something can be fair use if it isn't going to cost that person profit. That's kind of the metric there. And if I give my class of 24, or my classes of 24, since I teach usually 3 to 4 sections per semester. So even if I give my 96 students access to 25% of a textbook, that's unlikely to significantly cut into the profit that textbook author or publisher is going to earn. Now, again, that's a difficult metric to sort of determine ahead of time, but for our purposes in terms of teaching and scholarship, it doesn't typically come up. Where it is much more likely to come up is with parody. And parody does fall under fair use. It is a protected use of intellectual property. But the question becomes, how do we determine that a work of parody has created enough distance from the source material that it isn't violating copyright, that it falls within fair use, etc., etc. The one sort of exception to the one exception sometimes that you get, especially in the age of YouTube, sometimes with YouTube criticism, you will get intellectual property complaints. Sometimes that is basically just meant to try and silence criticism of companies or of media or things like that, but generally not. The most common issues in terms of intellectual property and fair use disputes is with parody or original artistic works that incorporate other people's intellectual property as part of it. Probably the best known example of this is the debates about sampling in hip hop, right? A very common technique in rap, in hip hop, is to incorporate sections of other people's music and distort them, repeat them, change them, alter them in some way so that they're slightly different, and they perform a different function within the new song. This is a contentious thing. Back in the day, when Vanilla Ice's Ice Ice Baby came out, there was a lawsuit because basically they sampled from Queen and David Bowie's Under Pressure, and Vanilla Ice tried to argue, no, it's slightly different. We've got this little bit here that's not quite the same. But that was a big lawsuit. In a way that copyright lawsuits typically are not all that big and all that important to people outside the niche area of copyright law. But that is a big area where concerns about intellectual property actually sort of play out. People like Weird Al Yankovic, for instance, have built a career on parody. How do you determine whether or not he creates enough distance between himself and the source material that he's creating, that he's not just taking someone else's idea? This is a difficult thing. Sampling in hip hop is actually probably more of an issue because that does involve directly taking from someone else and then recontextualizing that material. But then you've also got things like, I forget the name of the photographer, but there's a photographer who has a whole series of pictures that's just pictures of other people's pictures. And not here it is in its context or anything like that. This picture, this new work of art is literally just a picture of the picture. And there were copyright laws about that, or there was copyright cases about that. There was a lawsuit saying it looks exactly the same. You put them side by side, you cannot distinguish which is the picture and which is the picture of the picture. But the judge determined in that case that the intent of that second picture, the cultural work, the artistic statement of the picture of a picture was different than the artistic statement of the picture. And so it was actually upheld. But it was never a sure thing that would be upheld. The judge could have looked at that depending on the way that individual judge read copyright law and fair use law. The judge could have looked at that and said, formally, these are exactly the same. They are indistinguishable. Therefore, you have violated this original photographer's copyright. So this is the thing with fair use, is it is designed to carve out a few exceptions, particularly for criticism, for nonprofit education, and for parody or recontextualizing an original work of art. But it's absolutely, absolutely not certain until a legal decision is actually handed down whether or not a particular use of copyrighted material will fall under fair use. There's general guidelines that can help you make an educated guess, but it's an educated guess until that is decided in a court.